Hello and welcome. We are planning to release a series of video on FAR, videos on important topic pertaining to FAR, such as why FAR being mandatory, pros and cons of FAR being mandatory, the role FAR plays in the trial, the impact of delay in registering the FAR in the trial, the impact of delay in sending the FAR report to the magistrate, and maybe perhaps the validity of second FAR, cross FAR, and we will cover various other topics and after the due research, and we will release it in the due course of time. This video will confine to the introduction and even sort of a prelude to what we are going to cover in future. FAR needs no introduction. We all know the importance of the FAR, the paramount importance, the prominence of FAR is very, very well known in the criminal law. It needs no explanation because the name is self-explanatory. First, information report. The information which comes first, which causes the police to commence the investigation, which causes the police to embark upon an investigation into the cognizable offence. Although the FAR is not defined in the statute, in the CRPC, the nomenclature is not used in the CRPC. In statute, it is given as in section 154, is given as a book to be kept by the officer in charge of the police station. The book in which the substance of the information which discloses cognizable offence should be entered. That book, it is what we call it as an FAR, first information report. And FAR's importance can be understood by various factors. One of it that is that it is mandatory on the part of police to register a FAR if information given to them discloses a cognizable offence. Even if the police knows that manifestly the information is incorrect, they bona fide think that the given information is wrong, inaccurate, still they have no discretion to make a preliminary inquiry or refuse to register that FAR. If there is an information, if that information discloses a cognizable offence, a mere information, if these two conditions are satisfied, existence of information and disclosure of cognizable offence, the police ought to enter the FAR, register the FAR. They have no discretion. And this is a settled portion of the law now, as it stands today. There were divergence of opinion before Lalita Kumari, but Lalita Kumari settled the matter once and for all. The Apex Court has categorically declared the law in Lalita Kumari. The Honorable Apex Court has declared the law in Lalita Kumari. We will discuss why, how they come to that conclusion. It may appear on the face of it as an extreme position, but there are solid reasons for that. Of course, it comes with its own pearls. There are a lot of downside in FAR being mandatory on mere information, not credible information, not reasonable information, on mere information. We will discuss in coming videos. But the law, the position today is that a mere information disclosing a cognizable offence, if brought to the police officer in charge of the police station, he ought to register the FAR. That's what the law stands today. And importance can be understood by the very fact there are cases where delay in registering a FAR will corrode the prosecution case in trial. Sometimes even it has become fatal to the trial, given the facts and circumstances of each case. So the FAR plays that important role. And without FAR, the police cannot embark upon the investigation. FAR is prerequisite. It's a sine qua non for the police to embark upon the investigation. It is mandatory. And when a law states that FAR is mandatory, then its prominence is well understood. Its prominence is quite clear, very apparent. We can even see the sequence of sections for FAR and the power conferred upon the police to investigate the cognizable offence. The FAR comes under the section 154. The power of police to investigate even without an order of a magistrate. The unfettered power to investigate a cognizable offence comes under 156. Then the peremptory direction given to the police on how to conduct an investigation, what should be done once a FIR registered, comes in 157. Even that sequence, the FIR comes first, then the power, conferment of the power comes next. So, in that by logic, we can understand that FIR has to precede the investigation. The investigation starts with the FIR, and then only they can go and do other work, like going to the spot or collecting evidence, inquiring, summoning witness, or even making arrest. So FIR is the first step in the criminal investigation. The question may arise: what if the information is utterly wrong? Can the police have some discretion to even just make a preliminary inquiry? I will give an illustration. Let's say that A comes to a police station. A gives information to the officer in charge of the police that X has stabbed Y several times. It happens that X house is just located few buildings away from the police station. The officer can very well ask someone, some police constable in the station, to go and check whether the information is true or not. He has the means to do that, but he does not have the power to do that. That can be construed as a preliminary inquiry that is not permitted. That's what very interesting about the FIR, and it may sound a bit extreme, may even to the maybe illogical, but this rationalization that the Supreme Court has declared, it's on a well-founded ground. It has a strong reason to say that, and of course, the Supreme Court also will aware and recognize the downside of that. Still, it tilts towards a mandatory register FIR. And we will expound upon these topics in detail in coming videos. Thank you so much.